What at that time were you mainly specialising in when you started, or were you trying, in the sense, to get a wide and varied practice going?
I had no purpose in mind as long as I could get a brief and for either for an opinion or for a court appearance. And most of the cases that the juniors at the bar did in those days were in the petty session courts and the coroner's courts, or special courts set aside to handle the national security regulations.
Not many specialised in equity then, did they?
No, I think the thought of specialisation to the junior bar only occurred, I think, in latter years. Some did go to the bar with that particular purpose, and some succeeded because they were able to read with the juniors and get an introduction into that particular branch of the law. But a lot of time was spent talking legal matters at places like mock bells or Reppins, but mainly mock bells, and for coffee and playing. Perhaps some played dominoes, and some would discuss their cases. It was a good way of, if you had 3 or 4 juniors with you, or maybe a senior one, to practice seeking advice on your current opinion you were trying to write or your case you're about to undertake. So it was a learning process, even that was an enjoyable one.
Yes, but I think very importantly also, though, I think you were saying it was a self-educating opportunity. So I imagine for you at that time, you learned an awful lot in a very short time.
Well, one did, yes. And sometimes you learn very quickly too, because if you're offered a brief sometimes in the morning, you had to go out to Burwood or down to the Central Court somewhere. You learn quickly on the run.
Did you find that challenging? Did it sort of trouble you a bit at first before you got into the swing of it?
Up to a point, yes. Although, depending what sort of brief you got, sometimes you get a quite extensive brief. Sometimes you get one sheet of paper with instructions on them, and then you had to do the best you could when you got there. And you were up against the police prosecutors in those days, who were pretty experienced young fellows.
Yes, that would have been quite intimidating.
Not always helped by the magistrate.
Yes, but that of course leads to an interesting question. Magistrates had very different qualifications in those days to the way what they do now, and there was sometimes the inadvertent impression created of collusion, if you like, with police prosecutors. Well,
there was that feeling, not in all cases, but in many cases, that the association was too close. Never more manifest, though, than in the country areas.
Yes. Did you do a lot of work in the country?
I did, quite a deal, yes. A lot of circuit work, which I enjoyed because I came from the country anyway, and it was always good to go back and experience how they lived in other country towns away from my own.
Did you find that gave you a bit of an edge in being able to relate to juries there, and in terms of your cross-examination style?
You knew something about the stock, whatever was maybe critical of the case you're doing. Yes, it did help a lot.
Did you find yourself waiting around for a lot of briefs?
Quite often, yes. And it often came unexpectedly. I was never one to go home too early, but not before 5 o'clock anyway, or even 5:30. And it's amazing how many briefs one picked up after 4, because after the law list had been settled for the day, the counsel got jammed and looking for another counsel, and you had to then prepare overnight for the case next day.
Did you burn a lot of midnight oil?
Quite a lot.